contract law related questions or sections in an assignment or even in an exam paper are areas where your storytelling skills can come into play, and storytelling in a legal paper add a lot of insurance into your final marks. Remember that. So there's no other place than contract law for that kind of an approach. So here I'm going to discuss few cases where the story will add value to your final marks. The first one is about the unilateral offer. That means an offer made to everybody. Now, this is not a question that normally comes up, but this is related to invitation to trade. That means typical advertisements are what? They're not offers, right? We know that. But what if there is an advertisement that can be considered as an offer by the world? Well, there have been very, very few such instances, and this has been the most popular case in that regard. The case is Carlyle versus Carbolic Smokeball and Company. It's a nice story to add whenever you have something to write about invitation to treat, meaning advertisements, promotions, that sort of stuff, and your analysis on it. Pulling a case on that creates a very good story like this one may be good, actually pretty nice, so that the evaluate and the examiner knows that you have done some research or homework. Now, for a story, all you need is 4 sentences, maybe 5, 6 sentences. That's it. You don't need a lot to write. But the kick that you create in the mind of the reader that you have enjoyed contract law, right? Or you just show that you enjoyed contract law goes a big way in making your merit into a distinction, or hold on to a distinction, or even if you have a really bad mark, a good story here and there may pull the, mark upward towards the pass or even a merit. So benefits are plenty for storytelling in law, especially in contract law. So what happened in this case? So there was this smoke ball story. Uh, the case was in 1905 or something. The company said that they got a cure for influenza, and they put up an advertisement stating that in that advertisement that their smoke ball, the medicine, can cure all kind of ills related to influenza. And there was this Mrs. Carlyle. Many legal actions were filed by the women, right? I wonder why. And she saw this advertisement, bought smoke balls, and then used them. But she got influenza, and the company promised, mind you, £100 for anyone who catches influenza after consuming using this particular magic medicine called smoke ball. Company was very much sure that the medicine was very good. But then here, Mrs. Carlyle was ill. So she took the legal action. Then the company said, no, 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 we are not liable. Why not? Because, ours is an advertisement. Advertisement is an invitation to treat. So we are not liable. But here the court said something very different. Court said, this is more than an advertisement, more than an invitation to trade. This is too definite, too clear, too obvious to make it look like an offer to everybody, calling a unilateral offer. Some people call it a general offer. So the court was of the opinion that Mrs. Carlyle, by buying the smoke ball, has actually accepted the offer made by the company, because the company's advertisement was better than just an advertisement. So it was more than an invitation. So this is such a rare case. There have been very few such cases in the entire history of the world. So this is not invitation to trade. This is a case of what could be an invitation to trade becoming a general offer or a unilateral offer, because the wordings are very, very specific, very, very clear. Good story to add right into your answer paper. May need 5 or 6 sentences, but worth it. Try it. Next case, again, a counteroffer, a typical run-of-the-mill case called Hyde versus Range. right? I made an offer to sell my land for 1,000. Sorry. Yeah. And the other party says, no, my price is 950. And the other guy, wrench, right? Said no. So offer and a counter offer, right? But what happened later? Later, I think Hyde, right? Yeah, was willing to pay, 1,000 original offer. But then Wrench says no, no to that also. Then only he goes to the court. There the court said, yes, there was an offer to sell the land by 1,000, but you, who? Hyde has killed that offer by making a counter offer of 950. So once you kill an offer, that's it. The offer is dead. Thereafter, even if you up the price up to 1,000, there's no deal whatsoever. Counter offer kills the original offer. Again, a very good story to add. And don't make it a miss on this, right? So, counter offers, clearly communicated will definitely kill the offer. And that's the end of the road. So there's no other way you can accept the original offer thereafter again, because the original offer is dead. Then let's go for another case. This is again a very important one. Misrepresentation. Normally students have a problem analyzing misrepresentation because it requires a bit of words. But the best way is go through a case. That makes it easier to score points. Evaluators do not exactly like the theories. Evaluators, no, even the nosiest of one would love a good story. So, storytelling is not something to be missed. Derry versus Speak, a pretty good case, right? What was it? The company said that, they are using steam power, right? They wanted to, right? Expecting Board of Trade's approval, right? Approval was never granted, right? So, but the company was claiming that they are using steam power. They were claiming, they were advertising that they have the steam power without getting the Board of Trade approval, and the Board of Trade approval never came. So this is a case of boasting that you do before you get the permission. Company was right to get the permission, but the company was too much in a hurry to wait for the permission to be active. Yeah, the court said, you lied. What you don't have, you say you do have. And you did it with intention. You knew fully well that you don't have the permission to do so about steam power. And yes, it's true that you have asked for permission, but it's also true that you did not get the permission from the Board of Trade. So when that is the case, how can you tell others that you have the power, you have the capacity, right? But in this particular case, the court was of the opinion, you can't call it as a fraudulent misrepresentation, but more like an innocent misrepresentation, meaning that you did apply for it, right? So it could have come any moment, permission from the Board of Trade. So it was considered as not done with the intent to defraud the people, but just to be swift and quick, to be ready with the things the moment you get the permission. But thing was that they told the people even before they got the permission. But anyway, even for innocent misrepresentation, remember, you have to pay compensation, whether it's fraudulent, negligent, or innocent misrepresentation. The what you call the respondent would be liable. Not easy to escape. A good case to add, Derry versus Speak. Next one. Again, we call it Bettini versus Guy. It's about warranties and conditions. Again, don't waste your language on warranties and condition. Always pull up a story. That would give the mark, the full of it. So what was that? Yeah, check the case after reading this, right? So, oh no, I got that. Yeah. So there was this opera singer. She did the performance, right? But however, she cut bit of the rehearsals. So there are two things in the performance, right? First thing is rehearsals, then the performance. She did the performance all right, but was not exactly perfect when attending the rehearsals. Then the organizers of the musical concert refused to pay her money, telling that she broke the contract because under the contract she had a duty to do the rehearsals plus, the final performance. Breaking one of them, that means the rehearsals, the organizers said should be a breaching of contract. That means breach of a condition. But the court said no. Court said she has kept the most serious part of the contract, and what she has broken was the less serious part of the contract. So the court said this is insufficient to be what? Breach of contract. So it was what? Not a breach of a condition, but a breach of a warranty. Again, a good case to discuss. This one, Hadley versus Baxendale. Now, what's that? There's a thing called the foreseeability. How much do you need to pay when you break the contract? Well, you should be paying what you can reasonably assume and reasonably guess or estimate as the loss caused because of you. You are not liable for losses that are unreasonable. Here, what happened was, okay, there was a mill, that means a plant or a factory, which had a crankshaft, a key equipment in a factory, right? That was broken. So the mill owner gave the crankshaft to someone to go and take it to repair and bring it back. So, this particular person who took it to repair took such a long time to return it. And all that time, the crankshaft, without the crankshaft, and mind you, the case was in 1854, right? No chance of mobile phones or telephones, right? The factory was idle, could not be working because of the only crankshaft was broken. But the fact was, the person who was given the crankshaft to return, take it to repair and bring it back, did not know that without the crankshaft, the factory would not be working because it was not told to this person by the owner of this particular mill or the factory. Later, when the owner of the mill took legal action against the person who repaired the crankshaft for breaking the contract, number one, the undue delay in return. And second one, for the losses that he suffered as a result of the delay in delivery of the crankshaft to the factory. The court said, yeah, this person, that means the person who repaired the crankshaft, should be liable for the delays. He should have done it within a reasonable time. But the court said, no, the factory losses, that means the factory would be closed without the crankshaft. Well, that was not a fact that this person was told, and that was not a fact that this person was aware of. As a result, the court said, no, that was not a foreseeable loss by this person. Only for the delay, he had to pay. Remember this case also, right? Hadley versus Baxendale. And one more, Taylor versus Caldwel. Now, what's that? It's frustration, impossibility of performance. These things may come up when what you call as a discharge of contracts, right? These topics come out. Discharge of contracts is one tough question that you will have to face in contract law. And pulling up cases like this will help you. Now, what's this one? Here, what happens is, I am the singer. I booked into a music hall to conduct my musical concert. This was a long time ago case. Remember the age, right? 1863. So perhaps, maybe a piano concerto or something, right? And what happened? The night before the concert was to begin, the entire hall is gutted by fire, destroyed by fire. Right? Then I take legal action against the music hall owner. We call it the Surrey Music Hall case. It happened in Surrey, England. And I wanted to claim damages from the music hall owner, telling because of your carelessness, the hall caught fire. So I could not conduct my musical concert. pay me compensation. But there the court said the catching of fire of this particular hall was an act of God. That means a case of frustration, which happened due to not due to my fault and not due to the other parties, the owner's fault also. So there was no way that you can claim damages. It was an unforeseen event. That's what I said, an act of God. Right? A good case for you to remember. So those are the things, 5, 6 cases, right? So in any contract law paper, you don't have to overdo with so many stories, but make sure to tell really good set of stories, at least 4 or 5, maybe 6, maybe 7. That will have a huge impact even on the sections where there's no contract law as well. So, okay, keep it up.